In Geneva, at the first trial, I was acquitted. The judges highlighted several points, starting with the lies of the complainant, her contradictions, untruths, and inconsistencies that emerged through the investigation. It was especially significant to note that there was no factual evidence to support her claims. She spoke about hair extensions which allegedly had traces, yet no proof was found. She also claimed she was physically attacked, even using the French term baston, implying a severe beating, yet none of the witnesses who saw her the next day observed any signs of abuse or marks on her face. It's worth noting that, for all the complainants, it's the same story. Across both cases and investigations, there is no factual evidence of my guilt, neither evidence of violence nor anything else that supports the claims made in relation to the hotel rooms. In fact, those responsible for these venues have contradicted the accounts of the complainants. This is factual. From reception to housekeeping staff, no factual evidence supports the complainants' stories. This is something that needs to be stated and reiterated across all cases, without exception. On the contrary, what is evident beyond the lies is what I have often said. The file is empty. It lacks any grounds to accuse me, but is full of evidence revealing the lies of each complainant. In Switzerland, this was made clear. What remains are statements from psychiatrists or psychologists interpreting messages. But when reviewing these messages and even the analyses, the judges pointed out that the psychologists contradicted themselves. The complainant did not even tell them the truth. The complainant herself wasn't truthful with her psychologists. There were contradictions between the messages she sent me, which were intended to seduce, and her statements to the psychologist almost on the same day. In other words, she lied to the psychologist, lied to her therapist, and on top of that, she addressed her psychologist informally, which is professionally and ethically inappropriate. This raised questions about the nature of their relationship, and he struggled to respond. Furthermore, there was a prohibition for the Swiss complainant to see all her witnesses, including her psychiatrists, yet she met with all of them. This also played a significant role in my acquittal. In the Swiss appeal, all these elements, her lies, contradictions, and her unusual relationship with her psychologist, were ignored. Her psychologist even met with her between confrontations, which was prohibited. All these elements which cast doubt on the process show a decision in the second instance that contradicts the first without any new evidence. It's all based on reinterpreting messages. My lawyers, who literally read the messages, are accused of dishonesty for not analyzing them psychoanalytically in some symbolic interpretation. Yet when read literally, the messages say the opposite. What's particularly serious in this case is that during the appeal, with my lawyers and the judges present, there were no new elements, witnesses, or facts that could invalidate the first instance's decision. The appeal's decision to convict was based solely on the interpretation of messages, mainly by a psychologist who had a close, special relationship with his client. This led to a 180-degree shift in judgment, which is serious because it's based on nothing concrete, raising the question of whether the decision was based on the evidence or predetermined. The facts established in the appeal only confirmed what was already determined in the first instance, which should have upheld my acquittal and confirmed my innocence. As I have said, the file is empty of factual evidence. In neither the French nor the Swiss files is there anything that supports the assertions and testimonies of the complainants. Rather, the opposite is true. There are lies, contradictions, relationships, and 10 years of online activity suggesting ulterior motives. To construct the Ramadan case, they had to shift the focus onto psychology, psychiatry, and psychoanalysis with the introduction of the notion of psychological control, emprise. This concept is problematic for several reasons. There is no clear consensus, and the reports in my file are contradictory. Some experts clearly state that it does not apply based on the facts. Professor Giannakopoulos in Switzerland pointed out that there is no basis for such control or Stockholm syndrome, as nothing in the messages or the complainant's behavior before, during, or after indicates this. In France, the public prosecutor's review of the 4 cases found that in at least 3 of them, the women actually felt validated in these relationships, and there was no psychological control before, during, or after. So there are totally contradictory opinions here which do not align with the facts. Continuing the investigation, we see that a French investigating judge relied on reports that have been challenged for various reasons. The expertise of Dr. Zaghori was contested because he, after initially violating protocol by meeting the complainants against the judge's advice, copied and reused portions of a previous annulled report. Despite these issues, his expertise was retained, even though it was ethically and ideologically challenged, not due to his Jewish religion, as some suggest, but due to his ideological stance on Zionism. Religion has never been an issue in these cases, neither for the complainants nor myself. Yet, within the investigation, there seems to be an attempt to frame this as a tension between Islam and Judaism, which is not the case. This is genuinely about the psychological analysis. In terms of psychological control, experts agree that my behavior did not exhibit any signs of manipulation. On the contrary, this theory is projected onto Islam itself, implying that converting to Islam equates to psychological control, which is problematic. In Switzerland, there was a reliance on a psychiatrist close to the complainant, which contradicts the opinion of another expert who said it does not hold. Today, we have a public prosecutor and various experts stating that the concept of control does not apply, yet the indictment still builds on it, suggesting that my religious influence alone caused this control. This isn't a conflict about ideology between psychiatrists. It's a matter of scientific, professional, and ethical integrity. Nothing in the facts supports the idea of control. For 10 years, these women exchanged messages aiming to ruin my reputation, showing their goal was to bring me down. How could women supposedly under psychological control spend 10 years plotting against someone, exchanging messages with the goal of tarnishing a reputation? The idea of control doesn't apply here, either before, during, or after the relationships. Their lives continued normally, they maintained relationships, and exchanged messages filled with lies. The notion of psychological control in this case has been dismissed by both French prosecutors and judges. They have determined there is no basis for it, confirming that the evidence actually contradicts the accusations. These are cases without any supporting evidence, and even the central notion introduced is unsupported by experts, judges, and prosecutors. Why then has this concept been used? This is a significant question, especially when considering that the psychology involved in this case may conceal political motivations. Some individuals, like Dr. Zaghori in France, have connections to organizations spanning France and Israel, where I am portrayed as a threat. His role as part of a committee that labels me as an adversary raises concerns about his objectivity. Despite this, he was not recused, and he even made public statements about my case, resulting in a complaint before the medical board. When there is no evidence and psychology is used to mask political agendas, one must question how the case is being handled. Today, numerous experts, alongside a French public prosecutor, state that the psychological theory does not hold. When psychology fails and no evidence remains, what's left, if not a political decision to convict a name when they cannot reach the man himself?